Good morning. Thanks for joining us. We're going to get this thing started. Welcome to the NREM podcast, the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. We recommend that you consult with an attorney in your state regarding any specific legal issue that you may have. All right, everybody. Thank you for joining us today for our first ever NREM live stream and podcast. My name is Andy Fowler. Myself and my law partner here, Sean St. Clair, we're going to be your host today. We are the co-managing partners of the law firm of Fowler St. Clair. We've got offices in Arizona and Georgia. We're experienced in representing real estate investors and representing numerous investors in preparing their contracts, structuring their businesses, and pursuing specific performance and quiet title lawsuits on their behalf. The purpose of this show is to discuss and provide information on legal topics relevant to real estate investors. And now, as we get started, want to remind you of a couple things. We're happy that you're here. We're happy that you're a part of the show. If we're providing meaningful content to you, if we're providing content that's helpful to you, like it, subscribe to the channel. That helps us, and it helps us provide you more content in the future. With that, I want to start off, kind of, Sean, with a simple question, which is, why this show? Why now? Why is this important? Why do people care about this? And why should people care about this?
One of the things about our show is it's going to be unique in the sense that I'm not aware of any live stream slash podcast that's focused on providing legal information related to real estate investing. Uh, the As well as I think the information we're going to provide is going to be helpful. There's a lot of information out there. Some of it is from attorneys, and some of it is from investors themselves that are providing, legal information, legal advice, and not all of it is fully accurate. And so we're going to try to, find and locate the best attorneys in our industry and the ones most knowledgeable to specific topics related to real estate investors, and provide us in hopefully, and in our view, the most accurate legal information that we can provide.
Jumping on top of that, this is a show for real estate investors, but more specifically, we're talking about, or what are we talking about? We're talking about wholesalers, and I know we're going to get into, for those who are watching that may not know what that is, uh, into a more definitive description of what that is. But within the wholesaling community, there's kind of this level of misinformation or bad information out there, and I think what some of this podcast is meant to assist with is fixing that problem. Do you agree?
I agree, and I also want to throw a caveat in there when we use the term wholesaler. That's just one area of real estate investing that goes on. We also have, creative financing where you're not wholesaling. You're actually going to use maybe a seller carryback or other method to basically own the real estate and own a cash flowing asset. In that case, you wouldn't be wholesaling because a wholesale transaction contemplates an assignment versus creative financing, which is a whole nother niche of real estate investing, involves generally either purchasing the property for a long-term hold or maybe purchasing it to fix it up and then sell it.
Okay. The another dynamic I think that is important, and if you're just if you're if you're if you're not new to the real estate investment market, this might not be a new thing, but the conventional market that we used to know, or that we were all a part of, whether it was in buying our own home and whatever else, and using a real estate, using standard forms through whatever real estate department, using a title company, so on and so forth, going in and closing on a transaction. There's this kind of conventional wisdom that we're all used to that's behind every sort of real estate deal, but that's not really the case anymore. And I think even more so, this adds to the importance of this kind of show to address changes in market conditions, situations that involve maybe more sophisticated transactions, different transactions than the garden variety consumer is used to. With that, let's go to our legal update before we get into the deep substance of the show. And we like to provide our listeners with a nugget of information that they can use, they find valuable. So what do you have?
So today, what I want to talk about is the idea of coordinating your cancellation notices and cure notices in the purchase contract with those that you're going to find in an assignment. So, just to lay out a hypothetical, you have a property under contract and you decide you're going to assign your contractual interest. So, you're going to basically allow someone to have your rights as the buyer to purchase the property. And so you go and you find another buyer, an assignee of your rights under the contract. And that buyer is the one that's actually going to close on the property and perform. Well, if you do just a general assignment to that assignee, then they receive basically all of the rights that they're entitled to receive under the purchase contract. That includes the right to receive a cure notice in the event that they do not perform or they do not close escrow on time. So, a common scenario is you have a property under contract, you assign it, and then the end buyer is not able to perform for one reason or the other. They're just not able to perform, but they want to perform. Or maybe they're going to go and assign it. And that's what we call daisy chaining, right? They're going to go assign it to somebody else. And so they're hoping that that person after them is going to perform. And it just doesn't happen. Um, Depending on the purchase contract, if it has a cure notice, well, then the seller is going to issue a cure notice. And if you've done an assignment, just a general assignment, well, the end buyer has the right to benefit from that cure notice. And then you could end up losing that transaction because of the buyer's inability to perform. So, what I like to see is I like to see in the original purchase contract a cure notice between 3 and 10 days. But then in the assignment, you assign or the buyer, the assignor, the wholesaler, whatever term you want to use, in that assignment, they put in there saying, I'm going to assign everything to you, assignee or end buyer, except your right to be cured under the purchase contract.
Oh, interesting.
So you basically say, okay, if you don't perform by the close of escrow date, this assignment is done. It's over. It's canceled immediately. No cure, no right to a cure because I did not assign to you as part of this transaction the ability to be cured under the original contract. Now, if you have a cure notice then in the original contract, then, depending on how many days you put in there, it could be 3 days, it could be 10 days. You have the ability to figure out a way to save the transaction. Maybe it's finding another assignee, maybe it's closing on it, yourself. But that end buyer's out of the picture because the assignment provides for the immediate cancellation upon the failure to close escrow on the original close of escrow date.
So the lesson here is think beyond the standard form, because what I would imagine is going on here, right? Deals are happening fast and loose, and the opportunities are quick. Jump on them when you can, and it's not theoretically difficult to jump onto Google, let's say, and grab an assignment and a form assignment. But a form assignment, what you're saying, isn't going to protect you for these unforeseen seen circumstances basically down the road.
Exactly. If you just use a form assignment that you find on the internet, it's not going to have those, custom provisions that allow for you to be protected, and frankly for the seller to be protected. I mean, the seller is under contract, and they've entered the contract because they want to sell their property. They don't want to come to the close of escrow date and find out that, oh well, at this point, I can't perform, and I can't perform because the end buyer can't perform. So it's a protection for the original buyer and the seller in the transaction to have a provision like that.
Are you finding with more sophisticated clients that they're figuring this issue out? Is this an issue that's kind of learned in the fire of investment where you've got it wrong, or are they learning this just from getting savvy legal advice from attorneys like you or others?
A little bit of both. Obviously, the idea of this provision, um, you know, came out of actual practice, right?
Right.
Realizing that I'm losing these transactions because of these end buyers' inability to perform. And so, but now the advantage is that um, this is a known problem, and so hopefully, uh, if you do seek the proper advice and educate yourself as to the different issues that are out there, or traps that you can fall in, you won't have these issues, and you can avoid losing a transaction because you've planned ahead. You've done some preventative measures.
All right. So with that, let's move into really the substance of our show. The show was we use the term the Wild West, of the days of the Wild West over, and what we're really talking about is this idea of wholesaling, this practice of wholesaling, which has gone relatively ungoverned from state to state in recent years, but we're seeing legislation happen as a result of uh, well, like all things, with new ideas come, fortunately and unfortunately, sometimes regulation that comes along with that, and that's just the cost of doing business oftentimes. But it's our job to understand what that is, what that's gonna look like, what that means for our clients, investors, buyers, sellers, all along the way. So, the topic of this show is really about up and coming regulation, and we have some of that here in our state, which is the state of Arizona. But not just in this state, we think we're going to see this, um, in other jurisdictions as well, and to begin preparing for that. Now, I know you recently wrote on that, but why don't you give us kind of a primer on what, legislation Arizona most recently is facing in the area of wholesaling?
Yeah, so Arizona recently passed and was signed into law by the governor, a disclosure requirement for wholesale transactions, and basically it's called HB 2747 is the actual act, and it's going to go in section or chapter title 44 of our statutes. And um, basically, what this does is it requires that um, buyers who enter into real estate transactions with the potential to basically assign that transaction, that they disclose to the seller that they're a wholesale buyer. Then there's an additional disclosure requirement where they define this individual as a wholesale seller, where somebody has a contractual interest in real estate, and they're then wanting to assign that contractual interest, or they're wanting to um, uh, maybe even double escrow that property and sell it to an end buyer, have an end buyer own that property and really not take title, or on a double escrow only take title for, a very short period, so that the end buyer can ultimately be the purchaser. That language, and we'll get to that, is pretty vague. And I think we try to imply, what the legislative intent is. But it doesn't make a lot of sense in a number of ways. And like I said, we'll probably touch on that here in a little bit.
Now, we've been as attorneys, we've kind of been tracking this legislation for some time. Wh Where is the legislation at with respect to being law at this point?
With respect to it being law, it is signed by the governor. And so it's going to have an effective date. I'm not sure exactly what that effective date is just yet. It was signed about a week and a half ago. But this year it's going to be law, and it's going to be enforceable.
Now, we were recommending, I know, just tracking the legislation in its earliest form. Look, this is what's coming, these disclosure obligations. Get your contracts in order, right? Prepare for this. Are the disclosure requirements onerous under the legislation?
No, they're not onerous at all. It really, to comply, you just have to add a couple of words to the original purchase contract, and then basically a sentence to any type of assignment or purchase contract that will result in, say, a double escrow.
Alright, I know the first thing I think of, it really is any law, but as an attorney, the first thing I think of, how broad is this? What am I dealing with? What is the scope of this legislation, right? Um, so let's start with that. What does this law encompass with respect to, we know it's a real estate law, so what's covered, what's not covered?
Well, the first thing that it covers is basically any buyer that enters into a purchase contract, who intends to basically assign that purchase contract. They have to disclose in the purchase contract, or to the seller, that they are, and here's the term that the statute requires, they have to state that they're a wholesale buyer. And that's what they have to disclose. They have to say, you know, I'm a wholesale buyer. Now, what's interesting is there's a lot of, including contracts that, I've prepared, there's a lot of purchase contracts that already have similar disclosures in there. It says buyer's going to assign it, buyer's going to assign it for a profit. And, even some contracts say, in full disclosure, the purchase price may be less than fair market value. So now really what you're talking about is adding verbiage saying buyer is a wholesale buyer. That's it. That's what you have to put into the purchase contract according to the legislation.
So, but, does this law apply if I go sell my apartment building, my commercial property, or is this just, relevant to just my primary residence? Do they define the scope?
Yeah, they define the scope as being residential real property. However, this is where things become interesting with some of the language and some of the issues. It you, the term residential real property is used by the statute, and I'm going to read right from the statute, means real property with fewer than 5 dwelling units.
Okay.
That's the definition. So, what does that mean? Well, a strict reading of the statute would actually mean that commercial property would apply, even though it's pretty clear that when they use the term residential, that they're referring to residential. But on the strict definition of a property with less than 5 dwelling units, well, a commercial property has no dwelling units. So it definitely has less than 5 dwelling units.
Well, that definition includes vacant land, right?
Oh, yeah, it would
Yeah.
include vacant land because vacant land has no dwelling units. Now, I, th- you know, when you do statutory interpretation, you look at, everything involving the statute and the legislative history and the words used, and the fact that they use the term, the legislature uses the term residential. Um, I believe that it's really referring to any type of property that's zoned residential or available for residential use that or intended to be, limited to residential use that has less than 5 dwelling units. So, a triplex, a fourplex, a duplex, a single family residence, or a vacant lot within a community or that's zoned or limited to a residential use. That probably falls within that definition. I don't believe that commercial property is going to fall within that definition, and that any reasonable interpretation of the statute would involve commercial property. But once again, if you just read the strict language, that's kind of what you could come up with or argue.
Yeah, the language the language doesn't seem it is vague, and it seems rushed. Have you found other areas in the bill itself that are vague at best?
Yeah, I think there's a lot of problems with the definition of the term wholesale seller. So this is intended to basically foist additional requirements on someone who is going to who a buyer who has the property under contract, who is then going to assign their contract rights, or like I said, potentially double escrow. Um, Now, the term wholesale buyer and wholesale seller is referring to the same person or entity. It's the buyer, and the characterization or the term changes depending on whether they're acting in the capacity as a buyer or the capacity as an assignor of a purchase contract, or in the case of a double escrow, a seller under a purchase contract to an end buyer. So let me just read the definition of wholesale seller, and you can see what I'm talking about as far as the problems with the definition. Wholesale seller means a person or entity that enters into a purchase contract for residential real property as the seller, that does not hold legal title to that real property, and that assigns that same contract to another person or entity. So let's break that down a little bit. It's a person that enters into a purchase contract for residential property, not as the buyer, but as the seller, right? So you're entering into a purchase contract for residential property as the seller. Well, wait a minute. If you're going to assign your rights under a purchase contract, you're not entering into a subsequent purchase contract.
Right.
You're executing an assignment, and you're doing it as the assignor. So that, once again, looking at the express and strict language of the statute, an assignment may not apply. I think the legislature wants the disclosures that you have to give as a wholesale seller in an assignment, and better safe than sorry to put it in there. But when you read that, you're thinking, well, wait a minute, this doesn't apply to an assignment. This applies to a purchase contract that someone enters into as a seller. Well, then let's go on and continue. It's a person or entity that enters into a purchase contract for residential real property as a seller, that does not hold legal title to that real property, and that assigns that same contract to another person or entity. Well, when it says that same contract, it's referring to the purchase contract that person entered into as a seller.
Okay.
Well, if I'm a seller, why would I assign the purchase contract? Right? So
Right.
if this is trying to refer to a double escrow scenario, well, that's not how a double escrow goes down. You in a double escrow, you enter into a contract with the seller, and then you enter into a subsequent contract with a buyer whereby you have a markup, right? So, I'm going to buy it from the original seller for 100,000. I'm going to sell it to the new buyer, the end buyer, through a second escrow for 150,000, and my spread or markup's $50,000. Well, why would I ever assign that to anybody else so that they could have that $50,000 spread? That doesn't make any sense. You're not going to ever assign that as a seller. And so when you look at this language, you look at it and you think, well, when does this apply? I honestly am not sure, because the language is problematic. But once again, to be safe, I would put the requirement or the disclosure language in both an assignment and a purchase contract whereby you're doing a double escrow. To be safe, I think that would be smart from an investor's perspective.
So let's talk about obviously the purpose of the legislation was to foist disclosure requirements, so that parties to the transaction have some idea that that a wholesaler's involved, or that their contract might be assigned, despite the fact that their purchase contract already has an assignment provision in the contract authorizing the ability to assign. What what does the statute build in terms of consequences if if a wholesaler comes in, they mess this thing up, they don't put the basically one sentence language you think you need to be in there to comply with the disclosure requirements. So what is the so what here?
Well, before we jump down to the so what, I do want to cover because I haven't touched on it. Is the um, what does a wholesale seller have to disclose,
Mhm.
right? So we've talked about what the wholesale buyer has to disclose. They have to disclose that they're a wholesale buyer. So a wholesale seller. So assuming you fall within the vague and ambiguous definition of a wholesale seller, um, let's look at what the disclosure requirement is. So the disclosure requirement, and this is more onerous than just saying, "Hey, I'm a wholesale buyer." As a wholesale seller, you have to disclose that um, you are a quote unquote wholesale seller and that you do not hold equitable in excuse me, let me back up. You disclose that you're a wholesale seller and that you hold, so you only hold an equitable interest in the real property, and that the wholesale seller may not be able to convey title to the property. So basically what you're disclosing is, hey, um, ultimately there's this original purchase contract out there, and the seller's performance under that original contract and the contingencies that are found under that original contract are going to apply to my ability to basically um, cause the closing of the transaction to the end buyer, right?
Okay.
So they're basically wanting you to disclose, hey, all I have is a contractual interest, or the statute uses equitable interest. All I have right now is an equitable interest. I don't hold actual real title to the property. And therefore, um, I might not be able to convey actual title to the property. It's out of my hands. It's in the hands of the seller,
Right.
right? So ultimately, that's the disclosure that the legislature is wanting to see in either an assignment or, like I said, in my view, a purchase contract in a double escrow scenario.
Gotcha. All right. So, given the disclosure requirements for wholesale buyer and wholesale seller, so what happens if they get it wrong?
Yeah, if they get it wrong, basically the statute does not provide any form of, civil penalties, if you will. What the statute basically does is it provides the seller with a free out, and if the um, and the seller can retain the earnest money. So let's say that the seller finds out that the buyer has assigned the purchase contract and did not disclose to the seller that they're a wholesale buyer. The seller can say, hey, look, buyer, essentially you're in breach of the contract. And um, because you're in breach of the contract, I have the right as the seller to cancel this purchase contract and to keep your earnest money. That's the penalty.
Okay.
Is I get to keep the earnest money. What's interesting is what effect a cure notice would have in that scenario, right? Because in normal situations, when you have a cure notice under a purchase contract, if you as the buyer do something wrong, then the seller has to send you a cure notice before they can cancel and keep your earnest money. Versus the statute basically appears to be an immediate consequence, with no opportunity to cure. And I think the legislature meant that, right? Because otherwise, the statute would have no teeth if the seller had to send a cure notice and then you say, "Oh, my bad. Here you go. I'm a wholesale buyer," and it's all fixed. I don't think the legislature, meant for that to happen or wanted that to happen. But other than that, there aren't any civil penalties, any damage amounts, or other repercussions provided by the statute for its violation from the wholesale buyer perspective, right? Well, then what about the wholesale seller? What's the consequence there? So if the wholesale seller fails to basically provide or make the disclosures, then the ultimate buyer, which probably is the assignee under the assignment or any buyer under a purchase contract for a double escrow, the buyer has the right to cancel the contract and receive a return of their earnest money. So basically, they have a chance to say, "Nope, I don't want to do this. You didn't give me the disclosures that I was entitled to, and therefore I'm just going to walk away and you give me the earnest money." It basically gives the buyer a free out if those disclosures aren't made.
Now all of these remedies, these are all pre-closing remedies. Nothing in the statute allows either party to unwind the deal after closing. Is that right?
Correct. These are pre-closing remedies. And what's interesting is the statute states basically that if it's discovered or it's becomes an issue, and here's the words: any time prior to the close of escrow. So that would indicate that if escrow goes ahead and closes, there's no consequence. There's no ability to back out. There's no ability to come back and say, "Oh, I sold this property. The buyer didn't disclose that they were a wholesale buyer, and therefore I want to rescind the transaction." That doesn't appear to be provided for by the statute or allowed by the statute, because it very clearly uses the language "at any time prior to the close of escrow." So if escrow closes and those disclosures weren't made, that should be the end of it, from what the language indicates.
I would imagine what this may result in is, market participants who are fighting over deals, right? Or trying to get deals. And some of it's, first to the deal first to get it kind of thing. But if this provides basically a get out of jail free card if you didn't set up your contract correctly, I would imagine there's gonna be market participants out there to say, "Hey, look, I got a better deal to offer." Maybe you're not obligated under your current arrangement.
For sure. I think that this is going to be used potentially as a sword by competing investors, right? And we see this all the time where a property is under contract and the seller's approached by another investor. They offer them more money and convince them that they should be the one to have the contract and work with them in the sale of the property. And the seller tries to back out of the earlier contract. Well, now you're right that you know new investor, third party investor that's coming to the table a little bit late, but still wants to try to figure out how they're going to get a foot in the door. It's going to say, "Hey, seller, let me see your contract," and then they potentially would be looking at that contract and saying, "Oh, they didn't put in their wholesale buyer, and they didn't disclose that they were a wholesale buyer, and so, hey, yeah." we go ahead and cancel. So even though what's interesting is even though the legislature didn't put in there, these harsh penalties, that in and of itself could be a very harsh penalty,
Sure.
right? So, it's better now to, dot your I's and cross your T's, not so much for the, any type of regulation or damages, but the idea that you could lose transactions and give other investors in the marketplace a competitive advantage if your contracts aren't
Especially,
accurate.
you don't even have, the fact of if you don't have a cure requirement, a notice to cure the default essentially, which is what we would typically see in a real estate transaction. If it's immediate, as the statute seems to suggest, you don't even have the disincentive that somebody might go through, which is to say, "Well, I gotta go hire my lawyer to do a make sure they do a proper notice to cure and do all that. That's gonna cost me money. It's not even worth it." At this point, it appears to be just send out your termination notice and move on.
Yeah, right. And basically, um, it raises the question, and I'm going to answer the question here, my own question. It raises the question of, do you have a valid contract? Um, the answer is yes, you have a valid contract, but you may not have an enforceable contract. Meaning, if the seller goes and closes escrow and everything goes fine, then you had a valid contract and the parties performed and no harm, no foul. But if for whatever reason the seller wants out of that contract, they have a right to exit. You don't have an enforceable contract. You don't have the ability to go in and now force the seller to perform. So you have a valid contract, but not an enforceable contract, if that makes sense.
Sure. Um, I I don't know. It seems to me that the same context in, unlicensed contractors entering into valid contracts, but the law has otherwise said and penalized them, essentially saying, "Well, we're not gonna allow you to enforce that contract judicially." It feels very similar to that to me.
Yeah, and you're right. There's circumstances throughout our laws here in Arizona, contractors, the prime example where, hey, if you're unlicensed, you enter into a contract, and the homeowner or the property owner decides that they don't want to pay you, well, you have no enforcement mechanisms. You have no ability to go into court and compel payment. And so, likewise, here, you have a contract, but if the seller wants out and doesn't want to perform, you know, you normally what happens if the seller doesn't want to perform, you basically file a lawsuit, and record a list pendants and force them to perform. Um, you wouldn't be able to do that here, if your contract did not have that language. It basically, once again, just gives the seller an out that, you don't wanna provide to that seller.
Well, and and to compare it to something even closer to home to kind of see how extreme maybe the remedy is when you think about it. I mean, think about the standard real estate transaction with, well, I'll use Arizona's context here. The standard Arizona Department of Real Estate form that's used, that requires disclosures, right? It requires certain disclosures. We call them the SPUDs. But that contract has a mechanism for your failure to disclose that, right? And it isn't an automatic termination.
Correct. If you were to use the, Arizona Association of Realtors form, uh, it's gonna have a standard 3-day notice to cure. And so if, and it obligates the seller within a certain amount of time to provide the seller's property disclosure statement, right? Which basically lists out all of these different disclosures regarding the property. And if the seller doesn't provide that, then the buyer has the ability to, go and issue a cure notice and say, "Hey, seller, I need this." Now, if the seller still doesn't provide it after the cure notice expires, then the buyer has a right to cancel the purchase contract. But once again, you have a cure notice. And you have the opportunity to say, oh, yeah, I need to do that. I need to perform. I need to submit these disclosure statements. I need to, provide my loan information. All of these requirements, you can basically, without consequence, not comply. And then when you're given notice, go ahead and comply. This isn't the case. I mean, the minute that the parties sign on the dotted line, at that point, that's what's in the contract. Now, if I've, you know, um, if I were in a situation where I entered into a purchase contract as the buyer and I realized, oh shoot, I forgot that language. Now, hopefully your form always is going to have that language, but let's just say, you've used an old form that didn't have it or something like that, and you realize I have a problem. Well, in that case, I you should be able to comply, assuming that the seller is cooperative by doing, say, maybe an addendum or something else that's signed by the seller where the seller acknowledges that the buyer is a wholesale buyer and correct the deficiency before the seller cancels. Now, of course, you run the risk that you present to the seller. So I'm not going to, do that, that type of thing. But nevertheless, I would go back and basically try to obtain an addendum and say, hey, look, this language needed to be in there. And have the seller sign off. So now you've done that disclosure, and hopefully, avoided any future issues.
The bottom line seems to be, to me, that if you're a wholesaler, you don't get the opportunity to fix your mistake. I mean, isn't that it? The legislature's decided for this purpose, if you fail to disclose, you don't have the opportunity to cure.
Yeah, but as I was talking through that and the addendum thing, and then I glanced down and took another look at the statute that's seen here in front of me. What's interesting, is that, okay, let's say that you failed to have the seller sign, or failed to put in the purchase contract that you're a wholesale buyer.
Sure.
What's interesting is, um, it states, and I'll read just the exact language. It's, subsection A1. A wholesale buyer of residential real property shall disclose in writing to the seller that the buyer is a wholesale buyer. Well, a few things are missing from that, right? The first thing is when. It doesn't say before entering into the contract.
Right.
So it doesn't have that language. So it doesn't say when. The second thing is it doesn't require that the seller acknowledge the same. All it requires is the buyer disclose in writing that they're a wholesale buyer. So once again, an addendum is great because then it shows that the seller received the disclosure. But could, an email, if the purchase contract says that, we can serve notices under this purchase contract by email, and if you then send an email to the seller subsequent to entering into the purchase contract that says, oh, by the way, I'm a wholesale buyer, and you disclose that through a written email that constitutes notice under the purchase contract, I'm not sure you haven't complied. That may be enough under the language of the statute to comply, is sending that subsequent email saying, hey, I'm a wholesale buyer. Now, the better method and the better thing to do is to have it actually, in the purchase contract itself, because then there's no questions. But, could you remedy the situation by, providing that late or subsequent notice? I'm not sure it's late because the statute doesn't say when you have to disclose.
Interesting. All right, we've mentioned a number of times you've written an article on this. I know you've shared it on Facebook and various platforms. A good article. We would encourage everybody to go out and find that. Sean, where can we find that article?
So I've posted the article in a couple of locations. So first is on our firm's website, fowlerstclair.com. You can go there, and I believe it's under the articles or blog section of our website. And then the other area that I've posted it is, I have a Facebook group that's called Real Estate Investor Legal, which is really designed to create a community of legal professionals throughout the country and investors, and connect them so that um, investors can locate, legal professionals in other states that can assist them with, these unique transactions. I receive a request for referrals on a regular basis, so I thought, well, if we could have this group and everyone's sharing resources and able to connect with attorneys outside of Arizona that can assist them with their needs, that would be helpful and a service to the investor community. So I posted that article in there. So if anybody wants to join that group, you can reach out to me on social media and I can point you in the right direction, or you can send me a friend request and I'll uh, and message me, and I'll invite you to join the group.
Awesome. Good information. Go out and get that article. We appreciate everybody coming to watch our live stream today. It's been fun, when we hope we find the information awesome and helpful to you. A couple reminders: we're going to be live streaming every Tuesday at 10 a.m. and hope that you're there to be a part of that. Don't forget to, like we said at the beginning of the podcast, like it, subscribe to our channel. We'd love for you to be a part of it. Want to talk about next week what we have coming up. Uh, Weathering the storm, clearing clouds on real estate titles. That is the topic next week. We have two guests. We're really excited about this. Tyler Epstein, an attorney and real estate investor, and Logan Fulmer, a real estate investor. They're going to join us answering questions for you all, and questions that we have. So make sure to be a part of that, and we will see you next week.